So I was not at the. I don't have evidence as to. I'm going off of the deed, and I view that as conclusive evidence. And
well, it's conclusive as to a purchaser without a purchaser for value without notice, right?
Well, correct.
It's presumptive as to any other.
Correct.
All right, go ahead, Mr. Bailey.
Your Honor, I actually have the transcript of the auctioneer. It's a very few lines. Would you like me to read that? It's very...
No, I just want you to argue your motion.
Okay. But just so you know, I have it. It's Exhibit B in the motion to dismiss. And that is the transcript from the auctioneer's sale. And it's in the answer. It is in the answer. Okay. All right, where were we? The purchaser at the trustee's sale was the beneficiary, Lehman Brothers Bank FSB, not U.S. Bank, as they claim. The record of the auctioneer's sale makes that clear. U.S. Bank was not present at the sale. The legality of the purchase by Lehman was dubious at best given the fact of its bankruptcy. The purchase by Lehman and immediate transfer of title to U.S. Bank was highly irregular. Notably, no mention is made of Lehman in the trustee's deed upon sale. I would like the court to ask the plaintiff how they came to own the title and interest as set forth in the trustee's deed upon sale. Then in the pleadings themselves, in the plaintiff's complaint, there are numerous errors and gross misrepresentations. I've covered that clearly in my pleadings, but in fact almost nothing they assert is true. U.S. Bank was never the lender. Payments were never due to U.S. Bank. The lender of record was Wells Fargo. The loan servicer was Wells Fargo. Payments were due to Wells Fargo. And it baffles me that they would state something completely contradicted by the documents, namely that U.S. Bank was in that position. All right. The presumption of compliance that you brought up, Your Honor, the trustee's deed shall raise the presumption of compliance with it. And the issuance of a trustee's deed being conclusive evidence that the statutory requirements for the sale were satisfied. It just doesn't seem to make sense that these entities can create a document and that becomes conclusive evidence, because quite honestly, there's a lot of fabrication of documents out there that the courts are seeing, and I've found a lot of them. So I would say that the trustee's deed upon sale is not absolutely conclusive in light of the untruths, the misrepresentations, the inaccuracies, and the irregularities that I've cited. It is absurd to claim that the statutory requirements for sale were satisfied simply because a document was created and recorded by a person with a vested interest in the outcome. I believe that the trustee's deed upon sale is a false document. The chain of title is broken, but the court may not adjudicate title in a forcible detainer action. The law in Arizona is clear that the right to immediate possession requires resolution of the question of title, but the court has no jurisdiction to determine possession, or unless the question of right is clarified, the court has no jurisdiction to determine possession. That's Padilla versus NCJ Development, a Texas case. And I think this is in my pleadings clearly enough. The fact is that if the question of title is so intertwined with the issue of possession, then possession may not be adjudicated without first determining title. That is case law, and I believe that is the situation that we're facing here, that title must be clarified. And I'm stating very clearly, I do not believe U.S. Bank has the right to this property. Somebody else may, but they certainly do not. So if possession may not be adjudicated without first determining title, then this forcible detainer action is the wrong forum to resolve the matter. The proper parties are not present in the courtroom. What about the new trustee, the new trust?
Okay. Are you almost, I don't want to cut you off.
I am, Your Honor.
You only have a short period of time.
I know. The plaintiff lacks standing and the court lacks jurisdiction. The plaintiff is not a real...
How does the court lack jurisdiction?
Well, the court lacks jurisdiction firstly because the proper parties are not in the courtroom, Your Honor.
Does that prevent the court from having jurisdiction?
I believe so. I believe that's one of the two forms of jurisdiction. And secondly, subject matter jurisdiction, the court does not have the jurisdiction to adjudicate title. That's my understanding. The plaintiff is not a real party in interest to this complaint as required by Rule 17A. As the plaintiff is not a real party in interest, the plaintiff cannot be an owner entitled to possession. Right of possession in this matter can only be determined in a quiet...
Let me stop you again.
Yes, sir.
I want to make sure that I'm understanding your position on the deed of trust. Is it your position that the deed of trust is a fraudulent document? In other words, the copy that's been presented as attached to the complaint is not true? It's somehow fraudulent?
Well, Your Honor, not the deed of trust. I assume that you mean the trustee's deed upon sale?
Yeah, the trustee's deed. Are you saying that that document is fraudulent?
I am. I am saying that that document was fabricated somehow to transfer title to U.S. Bank from...
No, let me stop you.
Okay,
Let me stop you.
okay.
My question is, in other words, if we looked at the original of that document, are you saying that the original of that document doesn't do what it purports to do?
Yes.
How?
Okay, that's a question that requires a good answer, Your Honor. I'm not suggesting that the document has been changed from what is on file at Yavapai County in the recorder's office, but as far as I know, the property was purchased by Lehman Brothers. I believe we can...
And I understand that's part of your
right.
argument.
And somehow it was mysteriously transferred on that same day to U.S. Bank. I just ask for transparency in how that was done and how that trustee's deed upon sale can be legitimate.
Okay, all right. Anything else before I turn it back over to Mr. Holbert?
Basically, that's it. I'm feeling that the right of possession can only be determined in a quiet title action. So I'm going to be asking the court to deny the motion and ultimately to order the parties to conduct a quiet title action.
Okay. All right. Mr. Holbert?
Well, Your Honor, I frankly am going to just leave it at this, but it seems undisputed that there was a trustee's sale. There is a trustee's deed upon sale that transferred the property to U.S. Bank. So U.S. Bank can look to a source. It can look to something and say that is the basis for us to possess this property. That is the right that we have to possess this property. The defendant in this case can't look to anything. He admits the property went to a trustee's sale. So he does not have the right of actual possession to this property. And so, I believe that the court's been presented with sufficient information. We would ask that the court issue judgment in favor of plaintiff, and then it determine that the plaintiff does have the right of actual possession, and that the defendant is guilty of forcible entry detainer.
Thank you. Mr. Bailey, let me ask you one question. The demand for possession of the property, I did not see in your answer where you denied that. You're not denying that you received the notice to vacate, are you?
No, I'm not. As far as I know, that was done properly.
All right.
I looked at that and I admit that was one of their allegations, that they had served that properly, and I admitted that. So I'm not contesting that.
Okay. And that you were served with the notice to vacate. Am I correct? Is that what you're saying?
Yes, I believe so. I'm not sure what the document was called, but I would say the answer is in the affirmative there.
Okay. All right. Thank you. Based on the arguments of counsel, I've reviewed the complaint and the answer. I'm going to deny the motion to strike, although I have only considered those portions of the answer that relate to the allegations set forth in the complaint. I'm simply not striking it because I don't find that it may not be relevant. Some of the information in the answer may not be relevant to the specific allegations, but I don't think that they rise to the level of material that should be stricken from the record. So I'm going to deny the motion to strike. But I have not considered those claim for relief and the answer fails to assert a legally sufficient defense. This is a forcible detainer action, and the sole issue is whether or not the plaintiff has a right to actual possession of the property. Issues that attack the validity of the plaintiff's title to the property aren't allowed in a forcible detainer action. The defendant in this case does not dispute that the trustee's deed was delivered to the plaintiff. They simply are challenging that trustee's deed as being invalid. The defendant also does not dispute the fact that the notice to vacate was issued and properly served. Based on that, I'm going to grant the motion for judgment on the pleadings. I have a form of judgment that has been previously provided. I'll modify that slightly. I'm going to sign the judgment today. The judgment, well, first of all, I find that the defendant is guilty of forcible detainer. I also find that the defendant's right to possession of the property located at 2500 Page Springs, Unit 1 in Cornville, Arizona, is terminated, and that plaintiff is entitled to immediate possession of the property. It's further ordered that the defendant shall surrender the property, and if that is not done on or before October 1st, 2010, plaintiff can obtain a writ of restitution on or after October 2nd, 2010. All right, this is a no money judgment, vacating all further hearings in this case, and I'm signing the form of judgment today. All right, Mr. Bailey, thank you very much for appearing. Mr. Hogarth, thank you very much for appearing.